Hello everyone, and welcome to the March 2025 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway and I'm an executive partner here at our Troy office. Our March 2025 topics include a case law discussion. We'll be talking about some somewhat older cases, meaning 2023, but first up is True Care Physical Therapy v. Auto Club. This is a published opinion, and then next I'll talk about a unpublished opinion per the Court of Appeals, which was issued May 18, 2023, and that is the case of Spectrum Hospital v. Citizens. And then lastly, for our trending topics in PIP litigation, I wanted to discuss the testimony of biomechanical engineers and the pros and cons and benefits and how their testimony can ultimately aid your case. Now, the case of True Care Physical Therapy v. Auto Club primarily centers around these UR or utilization reviews. They were a pretty hot topic after the 2019 amendments and became a hot topic for a few years until recently it seems to have died down. But I did want to talk about how they came into play in those early years immediately after the 2019 no-fault reform. Now, as we all know, the 2019 amendments, the legislature enacted the utilization review process at MCL 500-3157A. So essentially here, providers who are unhappy with the insurer's UR decision have the ability to file an administrative appeal with the Department of the Department of Insurance and Financial Services, also known as DIFS. Now, so what happens is the insurance carrier gets the bills, and they've noticed that the plaintiff or claimant has been treating with this facility for quite some time and determines that a utilization review is appropriate. And that could be for a number of reasons. There's a lot of treatment or long-standing treatment, and the patient isn't getting better. But the utilization review pretty much discusses the utilization of those services in regards to the plaintiff or claimant. Per regulations enacted by DIFS, a dissatisfied party may appeal a DIFS decision to a circuit court. So what happens here is the utilization review is done, and then the plaintiff or facility is unhappy with the results for whatever reason, likely because either benefits have been suspended, terminated, or the utilization review said that the price that is being paid should be a different amount. Now, in True Care Physical Therapy v. Auto Club, the Court of Appeals held that Section 3157A does not require parties to provide or to file an administrative appeal. Rather, the process is optional, and providers may instead bring a direct independent cause of action as provided in MCL 500-3112. So what happened here is, and this is why we don't see them and they're not as common as they were initially, because at first when these utilization reviews became popular, it was argued by defense counsel and the insurance companies that you guys have to file an administrative appeal. And instead, what the current case says, no, you don't have to file an administrative appeal. You don't have to exhaust all appellate options. Instead, you can just go ahead, you get this utilization review back, and you can just go ahead and file a provider suit, which is what they were doing in the first place. So we're back to square one on this issue pretty much. And that's ultimately why you don't see the utilization reviews being as common as they were in those early years post no-fault reform. In the early years, it was a way to force the facilities to pay attention to their bills or be subject to slowing the entire process down, to only bill for things or to only utilize billing that is appropriate, or come into contact with this administrative review process. But instead, the case of True Care said that no, you don't have to do that. Insurance companies can still do the utilization review, but in response to it, you can just file suit. Next up, we have the case of Spectrum Health Hospitals v. Citizens Insurance Company. Now, this is an unpublished opinion per our Court of Appeals, which was issued May 18, 2023. Now, ultimately here, this case stands for that the evidence presented was insufficient for either party to prevail on summary disposition as to a 2018 injury and whether that injury met the causation requirements of the No Fault Act to make plaintiff's treatments reimbursable. Now, just by way of background, here claimant suffered a grade 3 left shoulder separation due to a moped accident in 2018, which films, the MRI films show that, or confirm that there was indeed a grade 5 separation by 2020. Defendants prevailed in the trial court on summary disposition, arguing that the claimant's documented left shoulder injuries in 2019 and 2020, which occurred at work, required the claimant to use reasonable efforts to secure workers' compensation benefits pursuant to MCL 500-3109, government benefit offset provision. Now here, the court pointed to MCL 500-3109 Section 1, which is essentially the set-off. Now, under MCL 500-3101 Section 1, benefits provided or required to be provided under the laws of any state or the federal government shall be subtracted from the personal protection insurance benefits otherwise payable for the injury under this chapter. 2, an injured person is a natural person suffering accidental bodily injury. And 3, an insurer providing personal protection insurance benefits under this chapter may offer, at appropriately reduced premium rates, a deductible of specified dollar amount. This deductible may be applicable to all or any specified types of personal protection insurance benefits, but shall apply only to benefits payable to the person named in the policy, his or her spouse, or any relative domiciled in the same household. Now, the court went on to analyze whether the trial court erred in granting summary disposition in favor of co-defendants on the basis of claimant's failure to use reasonable efforts to obtain workers' comp benefits. The Court of Appeals found error for 3 specific reasons here. 1, defendants could have pursued workers' comp benefits on behalf of claimant. They cited the Aldenalic v. Harco case. 2, whether the at-issue injury would have been covered by workers' comp benefits can only be decided by a workers' comp agency, which has the exclusive jurisdiction. And 3, MCL 500-3109 Section 1 does not absolve a no-fault insurer's obligation to provide benefits under MCL 500-3105, and thus if a jury concluded that the injuries arose from the 2018 motor vehicle accident, the insurers were only allowed to offset workers' compensation benefits as claimant was deemed to be entitled to by the agency. So ultimately, the Court of Appeals found that the evidence presented was insufficient for either party to prevail on summary disposition as to whether the 2018 injury met the causation requirements of the No Fault Act to make plaintiff's treatment claims reimbursable. Further, the court found that there was a reversible error in the trial court by holding that MCL 500-3109 Section 1 does not absolve no-fault insurers of liability for PIP claims. And finally, that the trial court lacked the jurisdiction to decide whether the injured patient would have been entitled to workers' compensation benefits, because only workers' compensation can decide that, not the trial court. Moving on to trending topics in PIP litigation. Again, I wanted to discuss the testimony of biomechanical engineers in PIP cases. Now, the admissibility of expert scientific testimony is generally covered by MRE, Michigan Rules of Evidence 702, and MCL 600-2955. Now, under MRE 702, if the court determines that scientific, technical, or specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact at issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise if 1, the testimony is based on sufficient facts or data, 2, the testimony is a byproduct of reliable principles and methods, and 3, the witness has applied the principles and methods reliably to the facts of the instant case. Now, under MRE 702, the trial court must function as a gatekeeper in making decisions regarding the admissibility of scientific evidence and ensuring that expert testimony meets those rules above standard and meets the standard reliability. My apologies. And that's the case of Gilbert v. Daimler Chrysler, citing the Daubert case, which is a seminal and important case when discussing expert testimonies and specifically biomechanical engineers. MCL 600-2955 provides that an action for death or of a person or for injury to a person's property, a scientific opinion rendered by an otherwise qualified expert is not admissible unless the court determines that the opinion is reliable and will assist the trier of fact. Now, in making that determination, the court shall examine the opinion and the basis for the opinion, which the basis must include facts, technique, methodology, and reasoning relied on by the expert. And the court shall consider all of these following factors: A, whether the opinion and its basis have been subjected to scientific testing and replication. B, whether the opinion and its basis have been subjected to peer review. The existence and maintenance of generally accepted standards governing the application and interpretation of methodology or technique, and whether the opinion and its basis are consistent with those standards. D, the known or potential error rate of the opinion and its basis. E, the degree to which the opinion and its basis are generally accepted within the relevant community. F, whether the basis for the opinion is reliable and whether experts in that field also rely on it. And G, whether the opinion or methodology is relied upon by experts outside of the context of litigation. So ultimately, it's not as easy to get this testimony in, and you've got to make sure that all of those factors, or at least most of them, are in your favor when trying to get the testimony of a biomechanical engineer admitted at trial. Now, in determining the admissibility of expert testimony, the trial court shall consider all of the factors listed that we just talked about, and the party offering the expert testimony has the burden of satisfying the preconditions established by these two controlling statutes, MRE 702 and MCL 600-2955, Section 1. Now, a court, like I just said, the court must consider all of the statutory factors in making the admissibility ruling, but evidence may be admitted even if some of the factors do not support admissibility. Rather, the pertinent determination is whether a scientific opinion is rationally derived from a sound foundation. And that's why it's important to kind of check off as many as you can. Now, it's important to know that an opinion based on hypothetical situations is not permitted, and that's long-standing law. But the law does not require that an expert have a full understanding of every fact in any given case, only that the proponent of the expert's testimony set forth the facts that would support a reasonable inference of a logical sequence of cause and effect. And that is all I have for the March 2025 episode of My PIP Monthly. Please feel free to contact me if you guys have any questions and or concerns. Thank you.